many of your clients or members or those watching may not realize this, but anybody who owns a property in unincorporated LA, as of January 1st, their right to counsel program just went into effect. So it doesn't matter what the property is. If you're evicting a residential tenant, they now have a right to attorney. And just to be clear about that, there are notice requirements that are involved with that right to counsel movement. So your property has to have another form that's been drafted by the county, posted at the property. If you don't post it, and you don't serve it with a termination of tenancy notice, then you're going to lose that eviction.
So the eviction process, so that's next top of mind. So let's address, say, how has that evolved over the last 12 months, and is there anything slated to change this year with respect to the eviction process?
Well, like I just said, now the tenants have more time to respond to a complaint when they're personally served. So that's one aspect. LA County has certainly seen a tremendous increase in the number of attorneys. Many of your clients or members or those watching may not realize this, but anybody who owns a property in unincorporated LA, as of January 1st, their right to counsel program just went into effect. So it doesn't matter what the property is. If you're evicting a residential tenant, they now have a right to attorney. And just to be clear about that, there are notice requirements that are involved with that right to counsel movement. So your property has to have another form that's been drafted by the county, posted at the property. If you don't post it, and you don't serve it with a termination of tenancy notice, then you're going to lose that eviction. So that's one aspect that's changing in unincorporated LA. The problem with that one is they say by 2030, they want that same program implemented in every single city in Los Angeles County. So that's coming. So in other words, every single residential tenant out there is going to get a free attorney. And that leads me to the next change we're seeing over the last year, Kris. Like I said, an explosion in tenants' rights law firms. They all want to get on that dole, right? They all want to sign up for that. It's easy money. It's like an insurance defense firm. The city is just funneling new cases. So an explosion in tenants' rights firms. And that's a double-edged sword as well, because some of them know what they're doing, some of them don't. Those that don't can create bigger problems than those that do, just because they make mistakes and the court grants them continuances. So it's evolving. The basic laws about eviction haven't really changed much. All the COVID moratoriums have disappeared. So now we've got these fire moratoriums that are popping up. We've got, state moratorium, county, and city that are the city has approved it, but they haven't actually passed it yet. That'll probably be next week. There's some changes in whether you can evict people for unauthorized occupants and unauthorized animals. Looks like the way it's going to shake out is that if the tenant or the unauthorized occupant or the animal is there as a result of these fires, that you're not going to be able to evict them for 1 year. There's, like you mentioned, I think you mentioned it in this interview, that there's this rent freeze that's going to be popping up, and that'll be a rent freeze for 1 year in the city of LA. So yeah, there's a lot of these little nuanced things that are temporary in nature, but they will impact evictions, and you're going to have to know those laws and know how they impact on the temporary restriction on evictions for those people who were impacted by the fire. My understanding, the way it's drafted right now, is the unauthorized occupant rather, is going to have to prove that they were actually displaced. They're going to have to provide an address. Hopefully they'll have to provide a lease or something like that, but we'll see how it pans out, what finally gets voted into effect next week. The eviction process hasn't really changed except that extension of 5 days to 10. The courts, I wouldn't say the courts are more backlogged than they were a year ago. They're still backlogged. And so things are now still taking longer than they used to take pre-COVID or even the beginning of COVID. But all in all, the process hasn't changed dramatically.
So so timelines was going to be my next question, because I get calls from our clients, landlords, all the time that are saying, my eviction took X amount of months. One person shared with me it took up to a year. And I realize, these are all different based upon the situation. But how much of that delay in time is due to, say, the landlord not being prepared and having the right documentation versus the court system being what it is because of the backlog versus the tenant rights lawyers that are basically saying, hey, let's just go to jury trial with everything, every case that comes. What's the mix there?
No, okay. So all three of those are factors. You're absolutely right. I have a client right now. I just spoke to her yesterday. She's coming up on a year on her eviction, and let me just explain to you. This is a strategy that goes on. Not every firm does this, so I'm not trying to imply that they do, but it does happen. We actually obtained a judgment in her favor after, I think, 90 days, and we were moving forward. Property got posted with a lockout notice, and then an attorney subbed into the case and filed a motion to set aside the judgment, lost that motion. So we were moving forward with the lockout again, brought another motion, which is called a 473B motion, and that's where the attorney says, hey, it's all my fault and you can't punish the tenant for my fault. And now we're into like 6 months, maybe even closer to 7. And the judge has to grant that. That's not a discretionary issue. It's a mandatory granting that. So that put her back, several months again. So these are attorneys playing games, knowing the system, knowing how to play that game. So that's one aspect of it. Another aspect of it is, it is true. The landlords, I should say, with the growth of these tenants' rights firms, things that used to be very easy and flowed smooth are now incredibly complicated. If you've ever done an eviction and you looked at the answer filed in your eviction, you'll see those answers are, 9, 10 pages with literally hundreds of check boxes. So if they're if they're checking all of the boxes and you're going to end up doing some discovery, that's going to delay the process. But also a big factor is the landlords who we've created a checklist now because we're starting to see this happen more and more. So now we've got a checklist where the landlords have to fill this checklist out. Okay, does your property fall under a just cause ordinance? Yes. Okay. Does that just cause ordinance require you to register the property? Yes. Is that property registered? Yes. So they go through and they check these boxes, and then they find out later, well, I sent my check in. I thought it was registered. Well, did you ever get a copy of the registration in the mail? No, I never got it in the mail. Well, then your property's not registered and your whole case has been a waste of time. Now you've got to start over. So if I could say one thing to anybody watching this, and I've been saying this for a year and a half now, you really have to know you can have a jurisdiction that has multiple ordinances that apply to your property. I know that we're talking LA and San Bernardino right now, but let me use Buena Park as an example. Buena Park does not have rent control. They do have just cause, okay? And the statewide Tenant Protection Act applies. So you can have a building in Buena Park that has the state's tenant protection for rent control and Buena Park's just cause ordinance for just cause. And if you don't understand both of those ordinances and how they apply to your property, and you haven't complied with both of those, the requirements in those ordinances, you may get halfway through your eviction and after discovery, the tenant's attorney discovers you haven't technically complied with one component of one of those laws, and your whole case is down the drain. So what I'm last year and a half, trying to persuade landlords is know exactly what laws apply to your property, download those ordinances, read them, and comply with them. And if you have questions, don't do it through the mail or email. Set an appointment with the appropriate housing authority. Go in and sit down with somebody and ask them, okay, I paid my registration. It hasn't arrived in the mail. What do I do? Right? I need a copy of my registration. Before you start any eviction, you have to make sure you've complied. Hyper-technical compliance. It's called strict compliance. There's no such thing as substantial compliance in evictions. It's totally strict compliance. One little non-compliant factor that you may not even know about, and you're dead in the water. And I'll give you a perfect example. In the city of Pasadena, notices have to have specific language about the tenant's ability to seek a reasonable accommodation. If you draft your own notice and you send that over to me, I'm going to look at it and say, nope, your notice is defective. Okay. But if you try to do your own eviction and you don't realize that, you're going to get down the line, and tenants attorneys, their goal is to keep those tenants in there as long as they can. They will not bring it up until the very end of the case. On the day of trial, they'll file a motion for summary judgment because your notice is effective. So keep that in mind. It's not going to come to the surface at the beginning of your case. It's going to come to the surface at the very end when you think you've won, and now all of a sudden some minor little mistake somewhere has caused you to start over. So the time frame, let me give you an example. The majority of cases are going to get settled anywhere between 90 days to 6 months, 3 to 6 months. That's the majority of cases. In egregious situations where you've got tenants' rights attorneys playing every game in the book, and possibly it's discovered that you didn't comply with something you were supposed to, that's going to take, if you catch it soon, you'll start over. Okay, you're on that 3 to 6 month track. If you don't catch it until the end, you're looking at 6 months to 9 months on the average, possibly even a year. If the tenants' rights attorney, for example, claims that you didn't comply, but you did, and you have to go through all this motion practice first before you get to your jury trial. And yes, everybody demands a jury trial now. Yeah, it is possible. A year is not outside of the boundaries.
Now let's shift to legal occupancy, and this might be a quick one, but I understand the rule's always been 2+1, 2 individuals per bedroom plus 1 person for the common area. Does that apply? And second to that is, let's say a landlord knowingly allows a tenant to have more people in a unit, more than the 2+1 rule, and something should happen in that unit. Let's say a fire or something. Something happens to somebody. Could a landlord somehow be at fault because they knowingly allowed too many individuals, quote unquote, too many individuals in a unit?
You would think that'd be an easy question. It's not easy. So let's start with your lease. Your lease, I'll talk about the 2+1 rule in a second, but let's start with your lease. Your lease controls who's allowed to be in that unit. So use that as a tool. Start off with that. You got to use an industry standard lease that specifically says, hey, nobody other than who's listed here. The 2+1 rule is not a law. It's a rule of thumb. That's why it's called the rule. And it's a rule of thumb that varies. Housing says that it's basically 2 people per bedroom plus 1 for the common living area. But if you've got areas, for example, Los Angeles, where you have certain demographics that have larger families, then that rule is going to have a lot of flexibility built into it. And now, on top of that, you've got to layer the local ordinance. For example, City of LA, their rent control ordinance says that you cannot, the tenants are entitled to 1 additional adult occupant or a newborn child. The additional adult occupant, they're just entitled to it. So that even though your lease says you can't have anybody more than who's listed on the lease, they get 1 additional. You do have the right to screen that person, and if they don't meet your criteria, then you have the right to get rid of them. But they are entitled to 1 more. Going back to that 2+1 rule, many cities are starting to limit your ability to evict people for unauthorized occupants. And they'll put some parameters in there as long as it's a family member, as long as it's this. But I am seeing more cities limit it. On top of that, those cities that are limiting it, I'm seeing them say, as long as you can do it if they're exceeding the housing codes, limitations on occupancy. And the downside to that is the housing code is based on square footage and how much weight the floors can handle. And so you can get a scenario where, you're talking 20 people, 25 people in an apartment. So going back to your question, is a landlord exposing themselves to liability by knowingly allowing the property to have more people than they're supposed to? I would say that they are potentially exposing themselves if it leads to overcrowding, which oftentimes leads to rodent infestations, things like that, which would be detrimental to the health and safety of the people in the unit. And certainly if there was a fire and there was overcrowding and it could be established that because of the overcrowding, people couldn't get out and they died, yeah, of course they would. But again, if they were in a jurisdiction that said there's nothing you can do about that unless they're violating the housing codes, then that would be a defense.
So it's not, so let's say you have a 1-bedroom apartment, you originally leased that apartment to a couple. That couple then has a child somewhere down the road. They're still within the 2+1 rule for a 1 bedroom. Now they have a second child and a third child at some outside of LA City. Now they've exceeded the 2+1. So now at this point, can you ask them to vacate?
Everything used to be so simple to answer, and it's not. It will. So you said outside city. Let's even take them outside LA County. Okay, that'll make it even easier. It'll depend on whether the property falls under some sort of a just cause ordinance. If it's creating a nuisance, then that's one thing. But if it's not creating a nuisance or any other sort of problem on the property, if you fall under a just cause ordinance, and that just cause ordinance, let's say the Tenant Protection Act. Tenant Protection Act doesn't say you can evict people for overcrowding. Now, if the overcrowd, like I said, if it's leading to a nuisance, then yes, you could, because that'd be a different, it's not a no fault eviction, or it's not an overcrowding issue. It's the fact that it's creating a nuisance, like a roach infestation or a rodent infestation. So it's not a simple situation. Every situation on occupancy has to be looked at as a separate situation, and which laws apply to it.
Communication with tenants, whether that be grievances with a tenant, just side agreements, something that wasn't initially listed on the lease. How much, where's the thin line between, written notice and verbal agreement? Where do you start? I imagine you're saying put everything in writing, but what's the best way to communicate with tenants?
I wouldn't say put everything in writing. I do like it depends on what you're talking about. A lot of stuff should be in writing, right? If your tenant is submitting work requests and you're communicating about that, yeah, that stuff should be in writing so you can document and prove later. We were communicating, we were on the problem, we fixed the problem. Tenant wrote back and said, yeah, the problem's fixed. That kind of stuff should definitely be in writing. If you're talking about other issues, it may or may not be advantageous for the landlord to put that in writing. My word of caution with landlords is putting something in writing can be a double-edged sword unless you're very good at writing and you understand the concept of what in law we would call an admission. I see it all the time. There's emails that go back and forth between landlords and tenants where the landlord will say something where I just cringe and I'm like, man, I wish you wouldn't have written that, right? But if you understand that certain things, as the saying always goes, whatever you say can and will be used against you in court. If you're going to start putting things in writing, think about that, right? That writing's coming into court. So be careful what you say. Always act, if you're going to put stuff in writing, always act as if that writing is going to make its way in front of a judge. So be polite, be professional, try not to admit things. If a tenant accuses you of something, let's say the tenant says, for example, I told you about this 30 days ago and you haven't done anything about that. The last thing you'd want to write is, I know I've been so busy, right? That's an admission, right? You don't want to write that. Mm-hmm. So writing is a double-edged sword. Like I said, if you're savvy about it, you know what you're doing and you can use it to your advantage to paint a picture through that writing that you're a good landlord, you're doing what you're supposed to, you're not doing what you're not supposed to. Writing's great. If you're not so skilled at that, you may want to think twice before you start putting things in writing. But other things, like I said, they should always be in writing. If you're fixing stuff, put that in writing. Yeah, we fixed this today. Seemed to work on our end. Do me a favor and confirm that it's working. Yeah, it's working. Great.
Discussing rent control for 1 second here. So obviously now there's several cities, as already mentioned here in our interview, where they have their own rules, their own ordinance. So there's nothing, statewide rent control is 5% plus the change in CPI. But then again, depending on the city you own in, could change from there. Some places are a portion of CPI. Some are just a flat cap. So it varies. And when landlords are, annually trying to determine how much they can increase their rental rates, I'm sure you get plenty of calls. Hey, Mike, I own in this city. How much can I raise my rents? Right? I'm sure that must be a very common call. I get that call often enough. What are just some general rubric here to tell folks in terms of here's what to be aware of, here's where to start, so that they can be more independent when figuring these things out?
Well, first of all, let me just make it clear that I don't tell people how much they can raise their rates. I don't do, even if I know, I don't do the calculations for them. There's way too much liability in that. And that's the kind of thing that'll come back to bite you 20 years from now, because if you do an increase that's illegal by even 1 penny, not only is that increase illegal, but every single increase after that is illegal. And so, there's a lot of liability in that. So I never tell them, I never give them percentages, amounts. I don't even check their work. But going back to the basis of your question, what do you want to do before you're implementing rent increases? It's a great question. As I was speaking to earlier, strict compliance is the name of the game. So, for example, if your property needs to be registered, you need to make sure your property's registered. If it says that you're not supposed to implement a rent increase until you've served a copy of the registration, make sure you serve a copy of that registration along with that increase. It's strict compliance with all of these just cause and rent control ordinances, and there's no flexibility whatsoever. So the rubric is get all your administrative stuff in line first. It's not difficult. If you have properties in several different locations, yeah, it gets a little bit tedious. But if you read the ordinance or, like I said, make an appointment with the housing department and go through with them, you can create a checklist, right? Is my registration paid? Yes. Do I have proof of that? Yes. Was it served? Yes. Do I have proof of that? Yes. Is it posted at the property? Yes. Do I have proof of that? Yes. Okay. How much am I allowed to increase? Well, I'm going to contact the city. City of Los Angeles, for example, they have a grid that you can go back all the way to I think it's 81. And it'll tell you the exact amount of percentage of increase that you're allowed to implement. Make sure if anything, you're going to round down by a penny, not round up. But you can create this checklist. Am I allowed to pass SCEP fees through? Yes. When do I have to do that? Well, you do that in June when you're doing your rent increases. Just line it all up and have a checklist you're using. And each year when you do that, go back in, look at the code sections and make sure that nothing's changed because they always change. In most cases, that stuff doesn't change too often, but it sure would be nice to have that confidence before you implement the rent increase that, yes, it changed. Yeah, now I need to do it that way. You used to be able to change security deposits in the same percentage as the rent increase. Well, that's changed now. So changes do happen, but you've got to stay on top of this stuff. And like I said, I'm a big fan of checklists. Every year you pull up the checklist, you go through it, and check things off, staple that to your notice of rent increase. I will say, Kris, shockingly, just for the people watching, I still see people who don't understand that 3 or 4 years ago, the law changed, the state law. And even in a property that is not under any rent control, if you're increasing the rent greater than 10%, even if, let's say 10.5%, it requires a 90-day notice, not a 60-day notice. And I still open cases where they'll send me their notices and we're looking at this going, wow, your rent increase from a couple of years ago was illegal because you went up, whatever it was, 13%, but you did it on a 60-day notice. And
when you say not, so we're talking about single family homes, properties built within the last 15 years, those sorts of properties.
Duplexes that the owner lives in one of the units. Yeah, anything that does not fall under any rent control and you can go higher than 10%, be careful because anything higher than 10% is a 90-day notice. And speaking of that, something just popped into my head. Based on the fires in LA recently, also be careful about Penal Code 396. That's a very strange situation. Even the Attorney General has been putting out.
You're talking about price gouging with respect.
Price gouging, right? There is a state. I think it's the Office of Emergency Services, so it might be oes.org or something like that. You can look it up. The Office of Emergency Services has a website, and it will tell you every state of emergency that has existed. I think it goes back 18 months or 2 years or something like that. If you look at it, somewhere in the state of California is a state of emergency at all times. There's never not a state of an emergency somewhere. And so the big question becomes, does Penal Code 396 apply to my building if there's a state of emergency up in Sacramento? And I don't have an answer for that. It's unknown. I can tell you with certainty that the Attorney General has prosecuted landlords in states of emergency where the emergency was in, for example, I think it was Sonoma County, but they prosecuted somebody over in Napa, or I might have it reversed or something like that. So I know it's not limited to the county the state of emergency is in, but how far does it expand? I don't know. And what I've been telling people recently is, we've beat Prop 33, we beat that again, right? 3 times they've tried to put statewide rent control, get rid of Costa Hawkins. And every time we beat it, they come up with a different way to backdoor rent control. And what I'm starting to see is with all like the Penal Code 396, what they're doing is administratively capping rents in California at 10%. Like I said, because there's always a state of emergency somewhere. So be really cognizant about that, and be careful how you're implementing these increases because they could come back to bite you later.
A question just came to mind that I've had quite a few times now. Let's say the time of year that your rental increase lands, or when you're supposed to raise your rents, is April. So statewide rent control says that it's 5% plus a change in CPI, year over year, April over April. So the new CPI for April of a given year wouldn't come out till May. Someone who's supposed to increase their rents in April, or even let's say May 1st, and the data hasn't been released by the Department of, was it Bureau, Labor of Statistics, right, or something like do you just go with the previous CPI? Do you have to wait until June? Like, how does this work?
Well, you could wait. You could use the previous CPI as long as it's less than the one that just came out. The other alternative is you can just wait a month, wait for it to come out. And just to be clear, unless this has changed, I think the Tenant Protection Act actually has two periods. It's got one in April and I think one in August as well. And so, like I said, I know it did. It used to have two, unless that's changed. But you could also wait a month. The Tenant Protection Act does not say you have to implement it in this month. It's just it says you're limited to implementing it one time per 12 months.
Got it. And you're saying, so this is news to even me. So you're saying that you're supposed to look at CPI for April and CPI for August, if let's say...
I'm sorry if that was unclear. To the best of my knowledge base, it would depend on, when your lease went into effect, but there were two CPI periods initially. There was one that would come out in April, and then there was one that would come out in around August, so you could do the increase in August, something along those lines. But it had two different periods, and you would come up with two different numbers for different tenancies. Gotcha. So I can actually double check that and circle back with you, Kris.
Sure.
See if that's still in place, but that's what it used to be. But to go to your question, what do you do if you put that tenant in there and in the natural course of events, the increase is supposed to take place in, let's say, April, but the information hasn't come out yet? What do you do? Well, I would just wait 1 month. Yeah, the tenant's going to get a 1 month benefit on that, but it would make it easier, especially on the next year when it lines up again. So just wait a month.
Now, I know at least for most of our clients, they run a good shop, but for many of them, even after hearing this interview, I know, like the thing about the good credit reporting, they're hearing that saying, yeah, well, I'm not going to do that and come sue me later. I'll let them, I'll take the risk, slap me on the hand. There's no way I'm going to start reporting good credit for all my tenants or give them the option to opt. I'm just not going to do that. They're more old school, but they run a good shop. If something's broken, they fix it, that sort of thing. Okay. So aside of that, where someone just blatantly saying, oh, I'm supposed to hang a notice. Yeah, good luck with that. I'm not going to hang the notice. Aside of those type of things, what are the most common mistakes that you again, time after time, you're just like, I still cannot believe. I talk at all these seminars. I've been to every AOA meeting. I've been on Kris's channel, and yet these people still keep doing X, Y, Z. What would be, say, the top 3 common mistakes they make that bring about legal trouble for landlords?
Mathematical errors in their increases. The 90-day notice I just talked about, not complying with the just cause, or I get landlords who don't even know which ordinance applies to their building.
I still get landlords that say they don't know there's rent control. So
exactly. So it's not staying up with the current laws, even though, like you said, they'll say, "Oh, I saw you on Kris's seminar," and then you go to start looking at their documents, and I'll say, "Well, clearly you weren't listening to the seminar, right?" But misunderstanding. It's confusing.
Sure.
The city of LA, right? You've got you've got property that fall under RSO, JCO, potentially the Tenant Protection Act, right? You've got multiple layers of laws that can apply to buildings. It's incredibly confusing, and I understand that, but that's where a lot of these mistakes come in. Another form of mistake that I see quite a bit, and this is diminishing as you and I were talking before the interview, that a lot of the older school people are selling, and we have a lot of a newer group of people coming in, first-time owners. The first-time owners tend to be more diligent about these laws. And the older owners, like exactly like you said, yeah, I'm supposed to put that poster up. I'm not going to worry about it. I'm not putting it up. I'm not going to tell the tenants about their rights. If I have to evict somebody, I'll put it up later. And not complying with these rules, even though they know about them, or just kind of at the end of their career as far as investment in residential investments go, and they're just not standing up on the laws. There's a lot of mistakes, misinterpreting things, believing that because you sent off your registration payment that you're registered and you've complied with the law. That's not what it says. So there's a lot of ways to make mistakes. There's a lot of variations of the mistakes. I will tell you a big mistake is right up front screening. It's I've been saying this for 18 years as I do these seminars. I have a 2-hour screening seminar, and I can't hammer it home enough. Screening is the key. Screening is the key. Avoid problems. It's all up front. It's all before you ever even have the tenancy. Screening, screening, screening. And I talk to clients, and they need to evict somebody, and 30 days after the person moved in, and when you talk to them about, well, what'd you see on the screening and stuff like, I really didn't run a screening report. Everything looked good from a first blush. I went with my gut. They seemed like a really nice person. You know what I mean? Not understanding the discrimination laws. I didn't bring it up, but I'll give you an example. We have a new law this year that actually exposes to landlords to liability based on a claim that the landlord discriminated based on an individual's hairstyle. So that is a new category, right? So now, if you don't take a tenant, the tenant can theoretically claim that it was based on a combination of their race and their hairstyle.
Right,
so it's not knowing all these subtleties in the law, and they're complex. There's just so many of them. Just since COVID, you and I have dealt with this. Just since COVID, landlord tenant law has exploded with new requirements and administrative components.
Well, and I think you'd hit the nail on the head that it really begins with your choice of tenant and the just who occupies your properties, and everything kind of dwindles down from there. It starts upstream with who's in your building. Will these folks be the type to be antagonistic and be problematic and these sorts of things? Like you said, too many landlords, out of convenience or I'm not quite sure what, but they just don't thoroughly do great background checks. They're not verifying with the previous landlord, what type of tenant they were, employment, and all the rest. So yeah, I believe it starts upstream with who lives in your building, downstream how many problems are you're going to have or not have from there. As we wrap up, Mike, I know that when we first started chatting here this afternoon, we discussed that places like the Inland Empire probably going to be some time before they have rent control because there's no city in San Bernardino County that has a special ordinance right now. Same probably can be said for Orange County, best to my knowledge, aside of Santa Ana. There's no special rent control ordinance. A lot of people are flocking there. So as we look out over the course of the remainder of this year, anything else on the horizon that you see impacting tenant landlord law?
I think, especially as we were talking about the people who are just getting into the industry right now, try to look as far ahead as you can into the horizon. I know, for example, we've got federal mandates, and California as a state loves these mandates. There are going to be changes. I see rent control just cause spreading, definitely. But I also see, for example, environmental changes. There are mandates that are already in place that are going to require landlords to retrofit their building from, let's say, some sort of a fossil fuel boiler or water heater to heat pumps that are all electrically driven. And so, as an investor, if you're looking down the line, ask yourself what to the best of your ability, because things can change overnight, right? But to the best of your ability, am I going to be able to get enough out of this? If I had to retrofit this building right now and put a heat pump in, what's the cost of that going to be? City of LA right now is still toying with that idea of mandatory air conditioning in the units, right? So yes, you're still going to see a lot of changes. We had a law last year, micro mobility devices, electric scooters and bikes and stuff like that. Where are we going? Try to look on a bigger picture. Try to stay on top of the laws and think to yourself what's coming. I will say, I believe those mandate dates will be pushed out because we're just not there. We don't have that infrastructure and that grid yet, but they're there and they're coming. You know, will they be implemented? I suspect they will over time. There's a the biggest one I could tell any investor right now is I didn't give you the list, but there's when I do this new laws and stuff like that as a seminar, I go through a whole list of all the new, the changes to a lot of the city's rent control and just cause ordinances, and they're just exploding. I will give you one example. City of Santa Monica has now created a protected category for your status, your housing status. So when you're screening tenants now, all of us would require, hey, you've got to have a 1 or 2 or 3 year good tenant history that I can verify. If you do that in Santa Monica now, you are subject to discrimination claim. A homeless person could walk up and apply, and you would have to give them that same consideration as somebody who's had the same residency for 15 years. So the cities are becoming just hardcore. A lot of them are. And I think you can expect that to continue under all circumstances. Job market's not great. The economy, some people think it's great. Some people see it as being on the brink. The housing crisis isn't going away anytime soon. And with all that on the plate, there's a lot of changes. And I think it's going to be all very favorable to tenants. So that's the best forward-looking prognosis I can give you.
Now, we have covered a lot of information in a short amount of time. I know there's some things that we didn't even have time to tackle. So Mike has offered to be generous enough to share his notes with us, his slide deck. So for those of you watching this interview, if you go to savemyapartments.com/Brennan, Brennan, savemyapartments.com/Brennan, share your email with us, and then we'll send to you Mike's slide deck, his notes that he created to prepare for this interview. And I think that's definitely going to be of use to you. Now, Mike, of course, here in a few weeks, well, by the time this interview airs, registration will open for our spring apartment owners educational luncheon. You've been nice enough to now be a part of this event for several years as our eviction specialist. For those who are qualified to attend, because seats are limited, and maybe who haven't attended prior, what makes this event unique, aside of, say, other events where they might be able to see you speaking there, what have you? Why should someone attend our educational luncheon?
As I say that every time we're there, I don't think you're going to get a better group of people as a team that you can put on your side of the table, whether you're buying, selling. I mean, you've got guys there that'll talk to people who are thinking about selling. You've got people there yourself who can talk to people about doing 1031s, exchanging, growing. You've got Steven Spear there, who is a general counsel, who's just incredibly knowledgeable, landlord himself. It's a great team. You've got people there on the accounting side of things. It's a great one-stop shop for a group of people who know what they're doing.
Yeah, for those that are not familiar, it's in about 3 hours, you get to hear from individuals from all the various facets of multifamily ownership, these various professionals that Mike had mentioned, and that's really what it has to offer, all free educational content. Mike, we look forward to you joining us then. And until then, sir, I wish you be well, and thank you for your time today.
Thanks, Kris. I appreciate it.
So that was a storehouse of knowledge for you. I hope you found today's interview informative. My hope is by viewing our channel, you are receiving that information that's helping you in the day-to-day management of your multifamily properties. We hope, my humble hope, is that we're making an impact as you're building a financial legacy with your multifamily portfolio. If there's other topics that you'd like us to cover, other individuals that you think are out in the marketplace that would be good for us to interview, other specialists of the various facets of professions in owning multifamily properties, share a comment with us here. I definitely will take a look at that. I definitely will consider your suggestions. If you haven't already, be sure to subscribe to our channel. We have hours and hours of content on our channel that's all geared towards educating landlords, informing landlords, empowering landlords in the ownership and management of their multifamily properties. And if you enjoyed the insights that Mike shared today, be sure to give the video a like. Again, go to our landing page, savemyapartments.com/Brennan, and we'll send you Mike's slide deck with all the notes. Again, all this information is free to help you, to empower you as the landlord. And this is Kris German, the apartment dealer, wishing you positive cash flow, tenants who behave, and much protection from Uncle Sam. Till next time.